Good evening. Let me just start over here. My name is Jocelyn Sedlett, and on behalf of the Board of Student Advisors and Dean Minow, I want to welcome you to the final round of the Ames Moot Court competition. This is a very prestigious competition, as you all know. In addition to those of you sitting in the courtroom here, we also have about 200 students downstairs watching in the overflow rooms. The case before the court tonight, Jimenez v. Holder, was written by Tejinder Singh, Harvard Law School class of 2008. The case presents two questions. First, whether an applicant for asylum claiming fear of persecution on account of his or her membership in a particular social group must show that the group has social visibility. Second, whether an applicant for asylum denied the right to the counsel of his or her choosing in immigration proceedings must show that the denial resulted in actual prejudice in order to obtain relief. The teams competing tonight are the Martin D. Ginsburg Memorial Team and the Constance Baker Motley Memorial Team, whose team names were selected during the semifinal round. Petitioner Martin Jimenez is represented by the Martin D. Ginsburg Memorial Team. Gerard Justin Cedrone, Jeremy Feigenbaum, Caitlin Halpern, Wookie Kim, Ashwin Pathak, and Jillian Sheridan Stonecipher. Gerard Cedrone and Ashwin Pathak will be making oral arguments on behalf of the team. The United States is represented by the Constance Baker Motley Memorial Team. Nicholas Bowie, Allison Deitch, Dina Hybe, Lucas Isakaroff, Andrew Rohrbach, and Kyle Wershba. Nicholas Bowie and Andrew Rohrbach will be making oral arguments on behalf of the team. The Honorable Ruth Bader Ginsburg, Associate Justice of the United States Supreme Court, will preside as Chief Justice of this final round argument. Joining her will be the Honorable Ilana Diamond Rovner of the U.S. Court of Appeals for the Seventh Circuit and the Honorable Merrick B. Garland, Chief Judge of the U.S. Court of Appeals for the District of Columbia Circuit. Please remember that no photography of any kind is allowed during the event or before or after. We also ask that you please remain seated while the oralists are speaking, and please make sure to turn off your cell phones at this time. Please also hold your applause until all of the oralists are finished speaking, and remember that there is a rebuttal argument after the two sides have argued. Best of luck to both teams, and we hope you enjoy the argument. Thank you.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business with the Honorable, the Supreme Court of the United States are admonished to draw near and give your attention, for the court is now sitting. God save the United States and this honorable court.
Be seated, please. We are convened in special session to hear the case of Martin Jimenez against Eric Holder. And we will hear first from the petitioner, from Gerard Cedrone. Please proceed.
Thank you, Madam Chief Justice, and may it please the court. My name is Gerard Cedrone, and I represent petitioner Martin Jimenez. I will be addressing the Board of Immigration Appeals' social visibility requirement, while my co-counsel, Mr. Pathak, will be addressing the question of prejudice in connection with the denial of counsel of choice. Our nation's administrative agencies are required to act rationally and to stay within the limits set by Congress. The Board of Immigration Appeals has failed to do so here for three independent reasons. First, in adopting the social visibility requirement, the board failed to even acknowledge that it was adopting a new policy. Second, the board's ultimate decision was contradicted by the very guidelines from which it claimed to draw support. And third, reading social visibility into the definition of particular social group constituted an unreasonable interpretation of the Refugee Act. This social visibility requirement was ultimately used by the board to exclude Mr. Jimenez from the United States.
In what sense is the social visibility requirement a new criterion rather than an elaboration of the Acosta factors?
It's a new criterion in a number of ways, Your Honor. First, for 20 years before the CA decision, the board used a one-factor test, the Acosta test, to determine whether a group was a particular social group. The only factor...
Let me stop you there, because your brief cites Acosta as a case very favorable to you. What was the group involved in Acosta?
The group in Acosta, Your Honor, I believe it was taxi drivers, Your Honor, in matter of Acosta.
And taxis drivers who refused to do the guerrillas' bidding.
That's correct, Your Honor.
And what did the Board of Immigration Appeals hold about that group?
The Board of Immigration Appeals, Your Honor, held that it was not a particular social group within the meaning of the Refugee Act because the group didn't share an immutable characteristic.
Well, when you compare your group to that group, it seems to me there was more cohesion in that group. You have all young men who don't want to do what the terrorists want them to do. There, it was taxi drivers who didn't want to do what the guerrillas wanted them to do. And if Acosta found that the group, it was not an immutable characteristic that bound them, then why are we talking at all about social group when this case should stop at immutability?
So, Your Honor, we think this case is distinguishable from Acosta, and we think it's more similar to matter of Fuentes, and I can explain why. The Acosta...
But before that, tell me what you think is a group that would qualify. Do you define it in a negative way? Anyone who is opposed to this MS-13? What is your idea of a group that would qualify as a social group?
So the group in this case is a group of young men in El Salvador who have resisted recruitment into the violent MS-13 gang. And that's what makes the characteristic immutable, is because the resistance is in Mr. Jimenez's past. In other words, once he's resisted the gang, he can't go back and undo it. And so in that sense, it is immutable within the meaning given in Acosta.
But the concept of a particular social group is amorphous. And applying it has always been a challenge for both the board and for the courts. Don't you think that the board should be given some wiggle room, some room to modify and elaborate on the meaning of that term over time? In other words, isn't the board trying to get at a practical problem here, which is how do you distinguish a true cohesive social group from those whose only common trait is that they have experienced violence? And that's what we seem to have here.
Your Honor, we agree with the board's statement in Acosta that it's going to decide the meaning of particular social group as framed in Acosta on a case-by-case basis. And indeed, this court has said in the past that we do defer to agencies in their interpretations of their own precedents, and we allow them to change their policies. But FCC against Fox television stations stands for the proposition that although an agency may change its policy, although it may elaborate a particular standard, when it is adopting a new policy, at a bare minimum, it has to acknowledge that it's doing...
So where did the First Circuit go wrong in Mendez-Barrera when it said this is merely an elaboration?
Your Honor, we think it went wrong because the test that the board had used for 20 years prior to CA was a one-factor test that only asked about immutability.
But if you could stop at the one factor, I would like you to answer my question of how this group differs from the Acosta group. That was the same group. Once the taxi cab drivers made it known they would not do the guerrillas' bidding, they couldn't go back again. So what is the difference between that group, which was held not immutable, and your group?
Your Honor, we understand part of the difference to be the difference is twofold. First is that Mr. Jimenez has resisted the group in the past, and that's part of the basis for the persecution, is that he has resisted the gang, and he can't undo it. Whereas in Acosta, the taxi drivers were being persecuted in part because they were continuing to be taxi drivers. The second difference is that...
Well, he's not going to continue, as much as I hate the idea that youth is not permanent, these guys are eventually going to grow out of being youths, and MS-13 is not going to have any interest in them. So that's not immutable.
Your Honor, we think that the facts of this, well, there's two answers that I'd like to give to that. The first is that Acosta uses immutable in a very particular way. It means innate or something that's so fundamental to your character or to your personality that you shouldn't be required to change it. And so that's part of the reason why we think this group is different from Acosta. It's easy enough to say you shouldn't be a taxi driver anymore, but it gets more to your character to say you should be forced to join a gang.
You're not always going to be 18 to 21. This may surprise you, but the fact is that eventually people get older and it will no longer, that aspect will not be immutable. The gang will not be interested in them.
I think the facts of this case demonstrate that if Mr. Jimenez continues to resist the gang, he won't make it past 18 or 21 because the gang...
In Acosta, the board said the group was not immutable because they could have, well, they could change jobs, that's number one. And number two, they could have done what the guerrillas bid them to do. And if that's the standard, could they do what MS-13 wants them to do? Yes, they could. So I really, sometimes, it helps to look at what the court did and not be so entirely focused on what it said. Don't you agree with that?
We do agree with that, Your Honor, and indeed we think that's part of...
Don't agree so fast.
Well, we do agree, Your Honor, because we think that's part of the problem below, and I can get to that in a minute. But again, I think the difference from Acosta is the fact that changing your profession from a taxi driver to something else doesn't speak to something that's fundamental to your character. It doesn't require you to violate some fundamental principles.
But look, isn't the social group of young men in El Salvador who resist recruitment into MS-13 defined solely by the fact of persecution rather than some independent, socially meaningful characteristic? Is every young man in El Salvador a potential target for gang exploitation? Should every man who objects, to gang affiliation and fears being a target be someone who is asylum eligible? Isn't that where you're leading us? You're leading us down the garden path.
I don't think so, Your Honor, because the group below can be defined, the group that the court considered below can be defined more narrowly than that. And it's people who have actually been targeted and who have actually resisted recruitment into MS-13. And there's nothing in the record to suggest that that's an all-encompassing group, that that's a group that...
Yeah, but the government has made the point that the gang will retaliate against anyone who gets in its way. So is persecution by a gang really limited to the young men that it tries to recruit?
Your Honor, I think the point I would make here is that the BIA applied the Acosta definition for more than 20 arguments without some sort of floodgates result, without some sort of parade of horribles where
because the result in Acosta was exactly the result that the government is seeking here.
It was, Your Honor, but again, I think, as I mentioned, I think the group in Acosta can be distinguished from the group below in meaningful ways because of that fundamental characteristic question.
You claim that the change occurred in 2006 with the CA case, right?
That's correct.
So that's 5 years before Mr. Jimenez crossed the border, 6 years before the BIA ruled in his case. Both of the cases you cite, Fox and State Farm, are cases where the change of course takes place in that very case. Isn't there some statute of limitations on changes of course by agencies?
Your Honor, I don't know that there is because...
So if it was 100 years ago, if they made that change 100 years ago, and for the last 100 years they had followed the new reign, you would still say arbitrary and capricious?
I think we would, Your Honor, but the response that I would...
Remember, arbitrary and capricious, this is a big thing. This is like Yale outranking Ames on the U.S. News and World Report. So how can it be, if you follow something for 100 years, that it would be arbitrary and capricious because 100 years ago you had a different course? I mean, if you take that view, you have to think about the cases in this court.
That's correct, Your Honor, but I think it would be arbitrary and capricious But it's very improbable that an agency would go that long without at some point acknowledging that it had made a change or reverting to its prior case law. I think the Fox rule is in part about the litigants in the case itself, but it's also a prophylactic rule. It keeps agencies, if the court reverses the BIA here, the BIA will know going forward that it can't simply adopt a new policy.
Would the same be true if it come out the other way? So since 2006, it's ruled at least 3 times against you, right, on this new way. So if they came out your way, that would also be a reversal, of course. Is that right? So basically, can't reverse what you did in 2006, and you can't reverse what you did in 2011. So you're like the donkey between the two hay piles. You can't do anything.
I think the second reversal that you're speaking of wouldn't really be a reversal because the board's never adopted the policy properly in the first place. It's never acknowledged its change.
But it has ruled in virtually identical cases, right? It has ruled that gang resistors are not refugees, right?
It has, Your Honor, based on that social visibility requirement.
All right. So you don't think it would be a reversal in this case to decide that gang resistors are refugees?
I think it would be a reversal in some sense, Your Honor, but it wouldn't be an invalid reversal because the policy was never properly enacted.
You would say if those other cases had come to this court, we should have reversed.
That's correct, Your Honor. And I think...
Can we...
Suppose the BIA had said, instead of what it did say, as you read it as not acknowledging that a change has been made, suppose they had just said, we agree with the Second Circuit and we agree with the European Union on the proper definition of social group. Suppose they had, would that be arbitrary and capricious?
I don't think it would have been, Your Honor, because presuming that they didn't purport to continue to follow the Acosta formulation, which we see as the key error in CA, the board said we continue to adhere to the Acosta formulation.
So if we returned it to the board, and now they see the light and they say, we agree with the Second Circuit and the European Union, not arbitrary and capricious. Is that what you want? It seems that that would be the end of the line, and there would be a lot of wasted motion.
Well, I think there's a couple of points that I would make. The first is we don't believe that the board is willing to take that step because in CA itself, it purported to uphold a bunch of its prior precedents that it would have to throw out if it properly adopted the social visibility requirement. There would also be a question of retroactivity, whether this new requirement would apply to Mr. Jimenez. Another important point I'd like to make is there's a second, I'm sorry.
Yes, I'm wondering if we could talk about who qualifies, in your view, as a particular social group. For instance, would informants against the gang, would they qualify?
I think under the Acosta formulation, Your Honor.
Sort of a yes or no, isn't it?
Yes, they would.
Okay. And what about reporters who would shine a light on the gang's illegal activities? Would they?
I think yes, Your Honor.
Yes again?
Yes.
What about community organizers who urge the government to round up gang members?
Yes, as long as they are being persecuted based on membership in that. Well, I think community organizers might get closer to the case in Acosta, and you might have a situation where the BIA would properly say, being a community organizer is not so fundamental to your identity that we would not require you to change that profession or that.
What about gunners in first-year law school class? Very fundamental to their sense of self, and I understand that Dean Minow is ostracizing them. What about them?
I think, Your Honor, assuming that they don't deserve to be persecuted. We would say that if we accept that it's a fundamental characteristic, then yes, it would be a particular social group.
But isn't it one that they should change?
I think if we take that as a given, that it's something that you shouldn't be required to change, then it would fit within the meaning of a particular social group. The board also committed a second...
This is a pretty broad definition you're asking. You can understand why the Justice Department doesn't want all the gunners from foreign law schools to come into the United States.
I understand, Your Honor, and I think under Fox, the board simply has to announce that it's making a change and do so properly. The board also committed another independent error when it claimed to rely on guidelines that directly contradicted its opinion. The board relied on the 2002 UN Guidelines on Social Protection, which adopted a disjunctive test.
But you're not really talking about the board misconstruing evidence, are you? Because the guidelines are not evidence.
Your Honor, we believe that State Farm stood for the proposition that whatever the materials or evidence or guidelines before an agency, they have to draw a rational connection between those materials and their ultimate policy conclusion.
But the board isn't bound by them, is it?
Your Honor, I see that my time is elapsing.
Yes, you can finish your sentence.
They are not bound by them, Your Honor, but they introduced them as materials they relied on.
Thank you, counsel.
Thank you.
Now we will hear from your co-counsel. Is it Mr. Fatak? Please proceed, counsel.
Madam Chief Justice, and may it please the Court, my name is Ashwin Pathak, and I will address the question of whether Martin Jimenez must show prejudice in order to obtain relief. The facts of this case are simple. The Board of Immigration Appeals, on a statutory command, promulgated regulations affording immigrants the right to choose counsel in a deportation hearing. Mr. Jimenez was denied that right, so he need not show prejudice in order to obtain relief for 3 reasons. First, the right to choose counsel in an immigration proceeding is certainly an important procedural benefit, not merely for the orderly transaction of business in the agency. Second, the right to choose counsel in a deportation hearing is a requirement under a statute duly enacted by Congress.
Why does that matter with respect to the harmless error rule?
So I think that matters, Your Honor, because this court has stated repeatedly, particularly in Caceres, that where a particular...
When was the last time we stated what you think we stated?
I think the last time this court enunciated the rule that for important procedural benefits, that when those are denied...
What year was that?
That was 1970 in American Farmland.
Right, now it's no longer 1970.
It is.
You may
That's
notice
true.
that this court has changed considerably.
That's true, Your Honor.
And since then, we issued the Shinseki case, in which we said specifically and expressly that the harmless error rule applies to administrative law. So I'm wondering whether you think that was a sub silentio reversal of course, and our court is arbitrary and capricious.
I don't think
Under
this court
Fox.
was arbitrary and capricious, Your Honor, and that's for a few reasons. First of all, I think that the Sanders case can certainly be reconciled with the Accardi line, including American Farm lines. In particular, that case, in that case, this court stated that where the natural effects of a particular error tend to lead to prejudice, it's certainly okay for an agency to have a per se reversible error rule. So I think that court certainly left open the door to per se reversible error rules.
Right, but
in
not
agencies.
eliminating, this is like your second or third prong of your argument. You're giving up your first prong, right? It can't be that the harmless error rule just doesn't apply wherever there's a statutory procedural right. The Accardi cases are inconsistent. If they meant what you said they meant, they'd be inconsistent with Shinseki, wouldn't they? Because in Shinseki, the court said that the same harmless error rule applied in civil cases will be applied in administrative law cases.
Certainly, Your Honor, and I think what the court had in mind there was simply that in agency cases, as in civil cases, due account must be taken of the harmless error rule. That's the language from the APA.
But due account means we don't reverse unless there's been a substantial prejudice to rights. That's what we have defined this by.
I don't think so, Your Honor. I think Accardi says the opposite. The Accardi line says the opposite, and American Farm line certainly said the opposite. And I think that in
Do you mean you take due account in some cases? You must. If you must take due account, that covers at least some cases. And you seem to be arguing you take due account in some cases, and in other cases you don't. So what's the difference between those two categories?
I don't think that's exactly what we're saying, Your Honor. I think that we're saying that you take due account as a general matter of the harmless error rule when determining whether agency errors require reversal. And then in American Farm lines, which came decades after the APA was passed, this court illustrated exactly what that meant, which is that important procedural benefits, when they are violated, a litigant need not show prejudice. Whereas
Let's go back to that basic point. Is there a right to counsel in immigration proceedings?
So, Your Honor, I think that, I guess that brings up a few different points. I think that we are certainly not arguing that every immigrant is required under the Due Process Clause to have counsel in an immigration proceeding. We're arguing two separate things. The first is
Well,
that,
so are you giving me an answer that you are not constitutionally entitled to counsel in immigration proceedings?
we are arguing that, Your Honor. However, that the entire constitutional analysis, we believe, is an even if argument that comes after the initial argument.
Well, it seems to me that you face this problem. 44% of the people who appear before the BIA are unrepresented. They have no right to counsel if they can't pay or find one. They would be out of luck. But a litigant like your client, who was able to get a lawyer, then has this right, this protection that he would never had if he were worse off to start with, if he had no counsel at all.
I would say two things in response to that, Your Honor. First, I would just say that if we are doing this constitutional inquiry at all, that means that this court has already determined that you must have a constitutional error, which we certainly contest. However, if this court is doing a constitutional analysis, then you're right, Your Honor. Certainly, 44% of immigrants don't have counsel in their deportation.
So does it matter at all, do you think, to our analysis that the statutory right to counsel is limited in some respects?
I'm sorry, I'm not.
Well, in
completely
other words, that
understanding,
it
Your Honor.
excludes any obligation by the government to pay for counsel if the petitioner can't.
I think that the only issue that is relevant here is the fact that an agency promulgated a rule that is required by statute that affords an important procedural benefit, and the agency violated that right.
If you're talking about procedural rights, and we compare these two people, Mr. Jimenez was represented not by the counsel of his choice, but by an able counsel. The next person to appear before the board is not represented at all, and he does a terrible job representing himself. In what sense would it be appropriate for the court to say that the person who couldn't get counsel and represented himself abysmally is out of luck, but the person who had able counsel can get a remand?
Of course, Your Honor. I think that there are a couple distinctions to be made between those two cases. The first is that in immigration proceedings, a number of circuits, in particular the 2nd, 6th, 7th, 8th, and 9th circuits, have all determined, and no circuits have held otherwise, that when an immigrant is without counsel in a deportation hearing, the immigration judge is required to take further steps to develop the factual record to ensure that there's a full and fair hearing before he or she makes a decision. So I think
and
that
who polices that?
I'm sorry?
Who makes sure that that happens?
That, of course, the immigration judge would have to ensure that happens, and it would be appealed if anybody thought differently. But
as between petitioner and the court, wouldn't you agree that typically the petitioner is much better situated to know whether he is being represented by the attorney of his choosing? I mean, I understand why in the unusual facts of this particular case that might not be true, but don't we have to think about the ramifications? What will the ramifications be for the system?
I don't think we should be too worried about the system, Your Honor. So first of all...
You must be kidding.
I think that regarding this, the issue of whether an individual would be in a better situated position, of course, this case is quite an obvious counterexample. In addition, I think that as a general matter, individual immigrants are already very much incentivized to ensure that they're represented by the counsel of their choice. However, the statute here doesn't require that individuals ensure that they have the counsel of their choice. It requires that the BIA ensure it.
Isn't this argument kind of upside down? So this person had a lawyer, not the one that he wanted, that he thought he wanted, but he had one who went to the Ames Law School and did a great job, right? Everybody agrees, great job, raised every argument. But if he had chosen his own lawyer, and let's say he picked somebody from Yale Law School, and they were not able to present every single argument, we would not say automatic reversal. We would say under Strickland, you have to show prejudice. Why should it be that if you pick your own lawyer and you don't get that one, but you get a great lawyer, it's automatic reversal. But if you pick your own lawyer and they do a bad job, you don't get automatic reversal. You're subject to the harmless error rule.
I think that's because of the difference between ineffective assistance of counsel and the right to choose counsel.
And what's the difference?
In Gonzalez-Lopez, this court stated that for ineffective assistance counsel, a prejudice inquiry is required. It is necessary to understand whether or not a particular litigant had ineffective assistance because something would have been different. But for right to choose counsel, the court stated that it would be an impossible inquiry.
The court said that, but the court also said because there was a Sixth Amendment right. So to follow up what my colleagues are saying, in order for you to win this argument, not only do you have to win this part of the argument, you have to win that there is a constitutional right to not only counsel of your choice, but to counsel at all.
I don't think so, Your Honor, and that's because in this line of cases, Strickland and Gonzalez-Lopez being included in that line, this court never required a constitutional error. What it required was a structural error in those cases. The fact that it was
structural constitutional error.
I don't think so, Your Honor. I think that in those cases, it happened to be a constitutional error because those were criminal cases, and in criminal trials, the vast majority of the rights granted to litigants—
What case has ever held a structural error that's not a constitutional one?
So I think that throughout the Accardi line, you had cases that did not do any constitutional analysis, and any of those cases didn't even hint at a constitutional analysis. And in fact, in a couple of them, Vitorelli and Service in particular, the court specifically stated that absent the regulations, there would be no requirement to follow any of those particular regulations.
They didn't actually mention harmless error at all, one way or the other in those cases, right? Those cases said that the agency has to follow its own rules, but it didn't address what would happen if there were error or not error.
I think the fact that this court made the decisions it did in those cases without doing a prejudice inquiry implies that there was no prejudice required. And in American Farm Lines—
A drive-by decision on that subject.
Well, Your Honor, in American Farm Lines, the court did specifically state what it was doing in those cases. In citing Vitorelli and in citing Accardi, the court stated that where an agency grants important procedural benefits, that agency may not violate the rule regardless of a prejudice.
No, it didn't say that. It said the opposite. It said that where it's only a merely internal, the agency doesn't even have to follow its own rule. It didn't say what would happen in the circumstance you're talking about.
I believe in that case, Your Honor, it did specifically state that for important procedural benefits, no prejudice inquiry would be required, and certainly that distinction—
No prejudice inquiry would be required in order to determine whether the agency had to follow its rule, but it didn't say what would happen if the agency didn't follow its rule.
I think that
You're free to disagree.
I'm afraid I do, Your Honor.
Let's go back to a prior step. I'm not clear on whether you are characterizing it as a structural error, are you?
So,
have you noticed this court's latest rulings, how it has handled the category structural error?
Your Honor, I think what this court has said—
The answer should be yes.
Yes, Your Honor. I am aware. In Gonzalez-Lopez, I think this court stated exactly what a structural error is. And one way that an error can be structural, that case stated, was that the consequences of an error are indeterminate in a way that it's impossible to determine.
Am I wrong in having the impression that this category, structural error, has been shrinking and shrinking so that now it's down to, well, if we labeled it structural error before, we won't go back on that, but no further?
It may be shrinking, Your Honor, but the right to choose counsel is certainly within it, and that was the court's decision in Gonzalez-Lopez.
I want to take you somewhere else. I want to take you out of this place. The first most obvious and most important mistake that was made here was made by Ms. Boyle. In terms of avoiding that kind of error in the future, wouldn't it be better or more effective to deal with the error through the attorney disciplinary system rather than by requiring a new hearing for Mr. Jimenez?
I don't think so, Your Honor, and that's because I think that this right is so particularly important. It's so important to litigants and immigrants in the deportation context.
And next time, he's not lucky enough to find someone who will represent him pro bono. We remand, and he has no lawyer, but that's okay.
That's okay, Your Honor, at least insofar as Congress has not afforded that right and is not required under the Due Process Clause. And we would just note that under a due process analysis, if this court goes to the due process analysis, which we believe it does not need to, under a due process analysis, the right to be given counsel by the government would be a vastly more costly right. And for that reason, of course, the third prong of the Matthews analysis would be dramatically different in that particular case.
You do recognize, do you not, that if we hold that your client was not a member of a social group, that's the end of it, right? There's no question about it.
I don't think we know that that's the case, Your Honor. I don't think we know what kinds of alternative arguments Ms. Boyle might have made in court.
Haven't you thought of all of them by now? Really? I mean, you're now we have a real lawyer, right? And the real lawyer of the choice of Mr. Jimenez, I assume. I don't know. I haven't seen the papers yet. But assuming that's the case, now we've got a real lawyer and a real lawyer who Mr. Jimenez has chosen. And if we reject every argument you've thought of, why should we imagine that some other lawyer who he also appoints will come up with any more?
Your Honor, I don't think that we've attempted to make all of the arguments that could allow Mr. Jimenez to stay in this country. What we did was
But he conceded that she provided him with strong representation and that he didn't suffer prejudice from her involvement in the case. And doesn't that put you in a very uncomfortable situation?
Your Honor, I think in Gonzalez-Lopez, this court specifically stated that due to the myriad aspects of representation, we just don't know what would have happened in an alternative speculative universe. In that situation, and I would just note that on page 6 of the record, we did specifically state that she could have done more. I see my time has expired. Thank you.
We're here now for counsel for the respondent, Andrew Rohrbach. Please proceed.
Madam Chief Justice, and may it please the court. My name is Andrew Rohrbach, and I represent the United States. I'll be arguing the social visibility issue, and my co-counsel, Nicholas Boyd, will argue the prejudice issue. Since its decision in CA, the Board of Immigration Appeals has consistently considered the social visibility.
Considered, or is it essential?
It is essential.
You agree it's a two-part test?
Yes, Your Honor.
So if the test before was one part, we have a problem?
Yes, Your Honor. The BIA has consistently considered social visibility understood as social salience of the putative group to determine whether that group constitutes a particular social group within the meaning of the Immigration and Nationality Act.
I understand that this is where you want to start your argument, but isn't the threshold problem here that the board was not forthright about its decision to change the Acosta standard to add the social visibility requirement? Take a look at Judge Hardiman in the Third Circuit in Valdivieso, Galdames.
We see the issue of what social visibility is to be the threshold question because the rest of the analysis depends on your understanding of social visibility. Judge Hardiman, for example, in that case, understood social visibility to be the on-site, ocular, literal visibility requirement that petitioner is urging. And we agreed that the board certainly did not give good reasoning for that requirement in its decision in CA.
So how in the government's group, the government says a group perceived by society as a social group. So what society? Are we talking about the local community, the regional group, the state, the nation, the world? What is the society that has to perceive this group?
In AME and JGU, the BIA has begun saying that the society must be the country in which the individual lives. But I would understand that that is the kind of consideration that the board will elaborate over the course of its adjudications and in the use of its expertise. The board elected to use the social visibility criterion in CA for 3 reasons.
So you agree that there was a change in policy, correct?
Yes, Your Honor, we do agree that it was a change in policy. And we believe that they adopted this change in policy for 3 reasons.
And yet you contend that we shouldn't make much of the board's comment about slipping into invisibility, which is the type of remark that seems to keep cropping up in these cases. And it goes to the very heart of the social visibility requirement. How can we possibly ignore the importance of the remark?
Well,
And wasn't the slipping into hiding argument essentially the very same argument that the governor made in Gattami and that the Seventh Circuit rejected?
But you were telling us, I think we would like to hear, what are the 3 qualities that you say determine whether it's a social group?
Well, the 3 qualities for whether, I can answer both questions at once, Your Honor.
Thank you.
The 3 qualities are whether the group is linked by an immutable or unchangeable characteristic, whether it has particularity or definable boundaries, and whether the group is thought of as a group by its society. It's
So
true.
on your test, take some of the petitioner's examples. Say a potential victim of genital mutilation. Is that a social group?
In CA, the board used that as an illustration of a group that is still a social group, even after its decision in CA, because it believed that a group like that is likely socially visible within its society. But this is a very contextual inquiry that depends.
What about then, if that's the standard, young women who are resisting forced marriage?
That has been a question that the board has struggled with, and that is precisely the kind of question that depends country to country. It is certainly possible that in some societies, in fact likely that in some societies, people forced into arranged marriages, men or women, are a social group treated as a group by the rest of their society. And it's also the case that in other societies, arranged marriage may not be a practice, and an individual may be forced into marital choices that they may not want to make without being part of a broader group.
How about girls who are deprived of education after early elementary grades? And that's what this society, that's the society's rule.
If that is the rule by law, then it's possible that that is good evidence for them to be a socially visible group under the definition.
So all the girls in countries that don't educate the girls would qualify.
Well, women are undoubtedly a socially visible group, Your Honor, and in society, there's certainly no question about that. And in a
It's a major concession we have here.
The line in the statute isn't a distinction between big and small groups. It's a distinction between groups and non-groups. And so in a society where women above a certain age are deprived by law of certain rights in a way that's offensive to our understanding of a society, then that's good evidence that those women are being persecuted because they're women. And so even though that's a large group, it's one that would satisfy the refugee definition.
Would all of the particular social groups recognized by the board prior to its decision in CA meet the social visibility standard?
The board has never said that all of its past groups would, but in CA it offered many of its past cases as examples which it thought would continue to satisfy the board's new social visibility approach.
Would a landowner or former member of the National Police meet the social visibility?
Yes, Your Honor. The board said so expressly in CA, and that is good evidence for why the board is looking to a social salience understanding rather than the literal ocular visibility requirement the petitioner is urging.
So what did they mean? What did the board mean when
Yeah.
it said that Mr. Jimenez could slip into invisibility? What does that mean?
In the decision below, as in CA, and in those two cases, the board has said that groups whose conduct is open and notorious are more likely to be considered a socially visible group.
Right, but in both of those cases, they're also more likely to be dead, right? So CA is a case about informants against the cartel, and the board says, well, you're not a you don't have social visibility until this cartel knows about you. And likewise here, you don't have social visibility unless you confront the gang and you tell them, I'm not joining. Sort of, there's a book, Catch-22. Doesn't it sound like that?
Well, I have two responses to that, Your Honor.
You
First,
only need one that's successful, that's all.
well, hopefully one of these two
Go
will
with
be
the best one.
The best one. There have been cases involving public witnesses, and that is the kind of conduct that is more likely to lead people in a group to think of that set of people as a social group. But the key is that that's what society thinks about the group, not necessarily whether or not the persecutors can identify individual members of their group. That's not the requirement that the board is imposing in its social visibility requirement.
But at the very least, look, if you're not defending a literal understanding of social visibility, then shouldn't we take that off the table, remand to the board to apply the social visibility standard without relying on a petitioner's ability to slip into invisibility? It is so amorphous. It is so Alice in Wonderland. It is so cruel. You're cruel.
The board is simply trying to administer the congressional statute, Your Honor, not in a cruel way. And in this particular case, the decision was already controlled by the board's precedent in SEG, as it's cited below, that this particular group, people in El Salvador who resist membership.
So you agree that test was a change in policy from Acosta. You told me that.
Yes.
That's why I asked you that question.
Yes, we agree.
So now you don't want to reverse the most recent case, but you're happy to reverse the cases before the most recent cases.
Well, if I understand Your Honor's question correctly, we agree that the petitioner can challenge the adoption of the rule because the board here relied on CA for the rule itself. But we think that SEG applied the rule, and so the panel of the BIA, which decided this case below, was bound by that precedential board decision to exclude Mr. Jimenez. With regard to the line slipping into invisibility, given that the outcome of this case was determined by SEG, the remainder of the board's opinion is discursive about several factors which weigh against thinking that the group Mr. Jimenez articulated is a socially visible one, but it doesn't.
Go ahead.
I was going to say,
I'm sorry.
It doesn't require remand since the board is already applying correctly the standard which it adopted in CA in 2006.
But if we find this word visible in its opinions, and we are genuinely confused on what the position is, why isn't what Justice Rovner said the right solution? Remand it to the board and say, now, you've used this word visibility so often, we'd like to know if it belongs or it doesn't belong. So tell us, and then, depending on what your answer is, there may be further review.
Well, in each of the BIA's cases since CA, it has looked to the same non-visible factors to determine whether or not a group is socially visible, notwithstanding occasional lines like slipping into invisibility. So we think it's the best reading of these cases is that the social visibility is the social salience understanding. And insofar as this court agrees, or at least thinks that's a reasonable interpretation of the board's cases, the board is entitled to affirmance here, even if it could have written a less clear opinion.
And I'd like to go back to a salient question that the Chief Justice asked you, and that is when you or the board say that a group must be visible to society. Who do we mean by society? If it's the gang that's doing the persecuting with the acquiescence or semi-acquiescence of the Salvadorian government, then why isn't visibility to the gang sufficient to meet that social visibility standard?
It is a factor in whether or not the group is visible to the rest of society, as the 10th Circuit noted in Rivera-Barrientos. And that's why the board looks to State Department reports and congressional reports and news articles to determine whether the incidence of violence against the particular group is greater, because the fact that persecutors in fact persecute this group more is evidence that they, and therefore possibly society, think of them as more visible. But the fact is that under these facts, if you will, the group that the petitioner is alleging is not persecuted more in society, or at least that is the finding of the board in SEG that's uncontroverted. And so it is not a socially visible group under the board's understanding of the term social salience.
Would you think would it qualify as an immutable group?
I don't
Because you have forthrightly acknowledged that there has been a change. You took the UN guideline, which was an or, and made it into an and. So I'm asking you, is this group immutable? Because if it's not, then why should we go on to the question of the social group?
While the board, I don't believe, has held one way or the other on this question, it has simply reached the particularity and social visibility questions to rule them out. I do think it would be an immutable group, because because to be immutable, the characteristic can be one that you should not be required to change. And we don't believe that people in Mr. Jimenez's position should be required to join a gang like MS-13 in order to save their lives or avoid persecution or something like that, Your Honor.
Well, let's say it like it really is. The underlying premise of your position seems to be that we cannot permit everyone fearing persecution to settle in the United States. But I wonder what that has to do with our legal interpretations of asylum eligibility. Either a person meets the criteria set forth in a statute or she does not. It cannot possibly be true, can it, that we base eligibility on how large a group we think might come floating through the floodgates later, can it?
We don't, in looking at individual groups, think about whether it would pose a floodgates problem. But in interpreting and administering the statute, the board is careful to ensure that it limits access to the asylum system to members of particular social groups and not every individual in society suffering persecution.
You answered the question that this group would be immutable, but yet in Acosta, the board held that a very similar group, strikingly similar, was not immutable.
Yes, Your Honor. The distinction...
Do you think the board was wrong at Acosta to say that those taxi drivers were immutable?
No, Your Honor, but only because we think that the board thinks that people should be required to leave their jobs in order to avoid persecution.
No, but that's not the only thing the court said in Acosta. I'm just going to read it to you. Neither of these characteristics is immutable because the members of the group could avoid the threats of the guerrillas either by changing jobs or by cooperating in the work stoppage that the guerrillas wanted. Now, you told us that it was immutable in this circumstance because they shouldn't be forced to join the gang. Why was it not immutable? Because it would be wrong to force them to cooperate with the guerrillas.
Well, first let me just
You
say...
like gangs better than guerrillas, or dislike gangs more than guerrillas? Is that the difference?
There certainly is a possible difference there, Your Honor, in that the Salvadoran government is trying to crack down on the criminal gangs, whereas the guerrillas were engaged in a civil conflict with the government that was different in character.
Well, they were certainly trying to crack down on the guerrillas. They were shooting them. The society, the government was,
Certainly.
the army was, so...
Certainly, Your Honor, and I see my time is almost up, so please allow me to repeat that the board has never made a finding on this immutability question to my knowledge, and certainly we don't rest on it in the decision under review here. the board only relies on social visibility as a way to weed out other groups like wealthy Guatemalans, the group in AME and JGU, who should not be required to give up their wealth, the board held explicitly in that case.
So
And yet-
we want wealthy Guatemalans to come here, but we don't want
Right.
people fleeing from gangs? Is
Oh,
that-
no, we excluded that group, Your Honor, because they were not socially visible and because they failed to satisfy the particularity requirement. I see my time has expired, but because the board adopted this with reasoned decision-making and it's a reasonable interpretation of the act, we ask this court affirm the decision below. Thank you.
Thank you, counsel. We will now hear from Mr. Bowie. Please proceed.
Madam Chief Justice, and may it please the court. Congress and this court have long directed judges to apply the harmless error rule when reviewing any type of proceeding. In crafting this uniform rule, neither branch carved out an exemption for errors committed by agencies. Petitioner concedes, and the lower court confirms, that the BIA's error in this case did no harm. This court should therefore affirm the judgment below.
Is it true that the majority of circuits hold that in asylum cases, when you're denied the right to counsel of choice, you need not show prejudice?
No, we disagree with petitioners on that score, Your Honor. While the Second, Third, and Ninth Circuit have adopted petitioners' understanding of the Accardi cases, no other circuit has, and indeed the DC Circuit, the Seventh Circuit, have looked to Chapman and this court's structural constitutional error cases to determine whether the denial of counsel amounts to a structural constitutional error.
So you're saying that the Ames Circuit Court was wrong in that regard, because that is what they said in their opinion, right?
I'm sorry, that the denial...
That the majority of circuits hold in the asylum context that denial of right to counsel of choice does not require prejudice.
That was an incorrect statement in the court below, Your Honor, yes. For example, the DC Circuit, in its decision in Yufeng Chung from 1969, held that while the denial of any counsel at all, because the hearing was held 25 minutes after the investigation.
So it's just a question, your difference with the Ames court is on how many are on each side of the divide.
That's correct, Your Honor.
The court said the Court of Appeals are divided on whether an individual denied the right to counsel of his choice must show he was prejudiced, and then its list shows the majority of circuits. But there is, at the very least, a division.
That's absolutely correct, Your Honor. And the source of this division comes from a misunderstanding of the Accardi cases. So the four Accardi cases, Accardi, Service, Vitarelli, and Yellen, are all consistent with this court's harmless error rule and with 706. The courts were silent with regard to whether the harmless error rule applies when an agency violates its own rules or regulations. However, many circuit courts have interpreted this silence as carving out an exemption from 706 and therefore not requiring the harmless error rule at all. However, the government interprets this silence as being consistent with this court's jurisprudence as opposed to creating a new and sub silentio exception. So
are you saying that in all those cases, although the court did not refer to harmless error, it found the error harmful?
that's correct, Your Honor. That would be the most natural interpretation of the cases. So in Service, for example, a foreign service officer was discharged after a favorable hearing was audited and then reversed by a loyalty review board, which violated departmental regulations. And in Vitarelli, an Interior Department employee was fired after a hearing that this court said lacked the, quote, indispensable indicia of a meaningful proceeding, including the ability to cross-examine the witnesses against him.
But how do you reconcile your position on prejudice with Vitarelli, which acknowledged that the petitioner could have been fired summarily and nonetheless ordered a new hearing based on the violation of his procedural rights.
In the harmless error context, this court has not defined prejudice as whether the outcome would have gone the other way, but simply whether an error contributed to the outcome. So in Chapman, for example, this court reviewed a prosecutor that had commented on a defendant's unwillingness to testify in violation of the Fifth Amendment. And this court applied the harmless error rule, but held that the prosecutor's comment was prejudicial, not because the defendant would have gone free absent the error, but because the error contributed to the outcome.
Well, if a showing of prejudice is required, then in the end, the right is not one to counsel of choice, but a right to competent counsel, even if it's not the counsel you choose. Is that right?
No, Your Honor. We agree with petitioners that there was a statutory right here to choice of counsel, not just competent counsel. And indeed, in Gonzalez-Lopez, this court held that those are two different inquiries. However, we still don't think that automatic reversal is appropriate here because this court's harmless error rule requires application of the harmless error rule unless there was a structural constitutional error.
Suppose he'd been competently represented by an attorney who it was later discovered had been disbarred. Would he still have to show prejudice?
Yes, Your Honor. Whether the attorney was qualified to practice before the tribunal is the same inquiry as here. The regulation violated, in part, was 8 CFR 1240, in which the BIA has said that only authorized counsel can practice.
But let's look at representation by a law student. Shouldn't the IJ be required to confirm that it is the petitioner's wish to be represented by callow youth?
Well, as a callow youth myself, I have to say yes. And
You'll grow out of it, don't worry.
thankfully, it's not immutable. But as far as what the IJ did, all the regulations asked of the IJ followed in this case, including asking for the
So then
EOIR.
why'd you confess error here? This is the part I'm a little confused with. Imagine that person had picked a name out of the telephone book and thought that they were getting X, but instead were getting Y, and they hired Y, and there was no way that the board could know. You're basically conceding whenever somebody doesn't get the lawyer he thinks he's going to get, that it's an error of the Board of Immigration Appeals. Why make this concession?
Well, because it's true, Your Honor. The statute was violated in this case.
True or required by the rules of the moot court? I mean, normally, if there's an error, it has to be committed by the government for it to make a difference, not if it's committed by the defendant himself.
That's true, Your Honor, and unfortunately, we were not responsible for the proceeding below. However, that said,
blame it on those lawyers.
assuming that a statute was violated in this case, the IJ did ask for the EOIR 28 form, and in that form, Ms. Doyle, the law student, testified under penalty of perjury that she was petitioner's first choice of counsel. So what petitioners are essentially arguing in this case with regard to whether there was a constitutional violation is that the due process clause required that the IJ do more, and that the IJ enact either additional procedural safeguards or have a colloquy with every law student or representative of an immigrant before the court.
Right. Look at the government, you, wringing your hands about the possible costs of a rule that would require automatic reversal when the petitioner is represented by someone other than the attorney he chose. But it would take 30 seconds. Do you have a stopwatch? 30 seconds for an IJ to confirm that the petitioner consents to representation by the law student who is standing in front of her. How much time does that take?
I have two responses, Your Honor. The first is it could take a very long time because in this case, petitioner didn't even know that Miss Doyle was not Miss Boyle. So had petitioner been asked this question or had the representative been asked, it's unclear that that would have solved the error.
But the IJ knew that it was a law student because the IJ has that M31 or whatever that form thing is that she signed that she was not an attorney. She's a representative. So the IJ knows this.
That's right, Your Honor, but had the IJ asked Ms. Doyle, do you have petitioner's consent to represent you? She would have said yes, as she testified in the EOIR 28 form. And from that perspective,
No, what the IJ would have said, Mr. Jimenez, do you realize that you are being represented by a law student? And he would have said, nope.
that may be in fact the case, Your Honor, but even then, the question required by the Due Process Clause is whether even this safeguard would prevent an erroneous deportation, not simply an erroneous choice of counsel. And when looking at it from that inquiry of whether this additional 20, 30-second or 20, 30-minute colloquy would result in erroneous deportation, the answer is no. And very minuscule number of
You do agree with your brother on the other side that if this were a structural error, it would override the harmless error doctrine, right?
That is correct, if it were a structural constitutional error.
So there's one criterion that's on every list of what's a structural error, necessarily unquantifiable and indeterminate. And we were just told, well, you never know what really the arguments a lawyer of choice might come up with. So isn't this a situation where the consequences are necessarily unquantifiable and indeterminate?
No, Your Honor. One way in which the error could, or the consequences could be quantified, and indeed were quantified, is simply by asking what would the petitioner's first choice of counsel have argued. In this case, the petitioner has not come up with any arguments, and indeed on page 4 of the record, petitioner conceded, quote, Ms. Doyle provided strong representation such that he did not suffer prejudice from her involvement. The BIA and the Court of Appeals below both interpreted that concession as well as the facts of the case to conclude that the first choice of counsel wouldn't have made any difference.
Isn't there a difference between making arguments and making them well? So imagine that these fine lawyers over here had been, had been arguing the case below and had persuaded the BIA to go the other way. Then all the deference would go in the opposite direction because we would defer under Chevron to any reasonable interpretation. So even if it's not enough of an argument to persuade us now to overturn on Chevron, maybe it would have been enough to persuade the BIA, which had more discretion, to go their direction because the burden of proof wouldn't have been the same.
Not necessarily, Your Honor, because the BIA found that the position was meritless, regardless of who argued it or the quality of the argument.
Well, it's easy to say, regardless of who argued it, but how do we know, as the Chief Justice points out? Of course they say, regardless, but they haven't heard the other arguments. They haven't heard these fine lawyers make their argument.
Well, if I can get at what I'm imagining is the root of this concern, it's that the harmless error rule requires speculation. It's impossible to know with certainty what a proceeding would have looked like absent the error.
And that's the point. You know, judges are human beings. And when a
Don't
judge
tell anybody that.
Two of the judges of this court are human beings.
I don't think Justice Ginsburg's willing to concede that either.
And, you know, when a judge confronts an experienced attorney who's handled 400 plus cases representing a petitioner, as opposed to a law student who has handled 4 cases, isn't it at least possible that the judge may give the seasoned attorney a bit more credit or think, this is a more important case? Isn't that possible?
It's certainly possible, Your Honor.
And can't prejudice arise from that scenario? You know, Gonzalez-Lopez makes the point that it's impossible to know what a petitioner's chosen counsel might have done differently. And that's another problem with a showing of prejudice.
Well, if I could
And those are two run-on sentences. Go ahead.
Okay, so if I could answer each question in turn. The first is that this court should not presume that simply because Ms. Doyle was a law student, she provided worse representation. The Stanford Law Review article cited by petitioners, the same page actually cited by petitioners, noted...
Didn't you read the New York Times about...
I did, Your Honor. I know that this makes
Just
me
checking,
look naive,
yeah.
but I too am a law student, so I feel like I have to defend my own. It noted that the Georgetown Law Clinic had a representation rate that was twice as successful as the average lawyer. And so it was something like 90% of people represented by law students.
But that's in Washington.
All that's to say is that it's not necessarily true that because Ms. Doyle was a law student, she provided worse representation. But to get to the larger question about Gonzalez-Lopez, and isn't this exactly the same? No, because Gonzalez-Lopez involved a criminal trial, and this court accounted for many of the myriad variables that exist in a criminal trial that don't exist in this case, such as voir dire, oral argumentation, plea bargaining. All of these variables factor into the outcome, which makes the choice of counsel in the Sixth Amendment context very important and impossible to determine.
So it's not that important which appellate counsel you hire. Is that that's going to put a lot of the Supreme Court bar right out of business?
I didn't mean to suggest that, Your Honor, but simply that a removal proceeding involves fewer variables, and so it is possible to quantify the difference between one counsel and another, as the BIA and the court below did. And in Arizona versus Fulminante, this court's 1991 decision, the court took seriously the finding of a lower court that an error was quantifiable. In that case, that involved an admission of an involuntary confession. And the Arizona Supreme Court found that this involuntary confession, despite the fact that it was an involuntary confession, was in fact harmless. The court took that seriously, and in part, on the basis of that determination, held that an involuntary admission of a crime is not a structural constitutional error. So too here. A removal proceeding is simply different from a criminal trial, not just because it involves fewer variables, but also because the Sixth Amendment is not at stake. And if I can return to the Accardi cases for a moment, the Accardi cases never suggested that anything less than a constitutional error is appropriate for automatic reversal. And American Farmlines does not contradict this, because American Farmlines simply held that some errors committed by or some departures from agency rules are not even reviewable, much less subject to harmless error. And they can only be reviewable upon a showing of prejudice.
You've hung so much on Accardi. Is it problematic, do you think, that the board, to my memory, never mentioned Accardi in saying that Mr. Jimenez had to show prejudice?
No, Your Honor, I see my time is running short, but may I answer the question?
Very briefly.
Accardi did not, or the board did not mention Accardi because Accardi is simply not relevant to this case. While the board recognizes that it was bound by its rules, it violated them, but it did not harm the petitioner. Therefore, we ask this court to affirm. Thank you, Your Honor.
Thank you.
The rebuttal argument, Mr. Cedrone?
Mr. Pata.
Mr. Pata, I'm sorry.
Thank you, Madam Chief Justice. I'll make just a few points in rebuttal. First of all, I think respondents are wrong to suggest that the Ames Circuit got the circuit split wrong. The 2nd, 3rd, 7th, 9th, and DC circuits have all held that where the right to choose counsel in a deportation hearing is violated, reversal. It is an error that should result in per se reversal. Now, what we would say is that the 3 cases that responded cites for the alternative proposition that prejudice must be shown actually don't undergo any analysis in those cases for explaining why they get to that result. And I think that's indicative. They didn't apply Accardi, they didn't apply American Farmlines, they didn't inquire as to whether or not the right to choose counsel in a deportation hearing was a structural error. They did none of that analysis. So I think that puts the weight of the circuit courts certainly on our side of this issue. The second point I would make is that in order for respondent to make their structural constitutional error argument, they must read in numerous different lines of reasoning into numerous different cases of this court. Accardi, Service, Fiorelli, and Yellen.
For you to win, don't you have to read out of the United States Code, the harmless error statute itself, that says, on the hearing of any appeal, that would be this one, or writ of certiorari, that would be this one, the court shall give judgment after an examination of the record without regard to errors which do not affect the substantial rights of the parties. So that's not just take due regard of the rule of harmless error. That is, unless there's an error that actually affects substantial rights, we have to disregard it. So unless you can prove to us this is a structural error, aren't you out of court on this argument about ignoring harmless error in the Accardi line?
I don't think so, Your Honor, and that's because I think that the burden is actually on respondents to demonstrate why this court should not apply its regular stare decisis principles here.
The reason they give is that there's a statute passed by the Congress of the United States. That seems like a pretty good reason.
And I think the response to that, Your Honor, is just that because this is a statutory right, Congress can simply change its mind. It can determine that the Accardi cases were wrong, and it can make that crystal clear. But because this court, in Accardi and numerous cases after, which came decades after the harmless error rule and have now been applied for decades since.
So you think we did reverse Congress, and we should just leave it that way?
I certainly don't think you did, Your Honor, but even if this court did find that they may be in conflict, I think that the rule of stare decisis should certainly strongly counsel this court in favor of upholding a judgment that lower courts have been perfectly capable of continuing to apply since then. Thank you very much.
Thank you, counsel. The case is submitted, and the court will take a brief recess. Be seated, please. I think everyone in this room will agree that we have been treated tonight to some exceptional advocacy. It's true of the briefs as well as the oral argument. It's very difficult to decide this case. But in the end, the business of a judge is to decide. So I will announce the divided decision about the best brief. 2-1, and I am not at liberty to say which two and which one, have determined that the brief for the respondent is the best brief. And our next chore is to decide the best oralist. And on that, our decision is Mr. Andrew Rohrbach. And that leaves us with the overall prize, which must be for the respondent. I can't avoid saying how deeply touched I was by the name adopted by counsel for the petitioner. I know Martin D. Ginsburg would have been so pleased to see that. And Constance Baker Motley was a woman I knew well and much admired, so made excellent choices. The reception is waiting, so I will ask my colleagues, first Justice Rovner and then Justice Garland, to make some very brief remarks.
I feel so privileged to have been here to be with Justice Ginsburg and Judge Garland, and to know that the law will live on in such capable and able hands. And for that, I really, really thank you. Thank you.
Well, that was brief. Well, I'll say something similar in a certain way. If we'll just keep it amongst ourselves, the level of argument here was better than the normal run of argument in the DC Circuit, which I think, in my own view, is pretty high. So you guys...
I'll second that.
Yeah?
But not in the seventh.
Which part? I think the... I think the particular quality, two points in the argument, and I think we can talk to the individual lawyers later, but 2 points I think are important about this. One is understanding by all four of you that this was a conversation you were having with the court. You weren't just getting up there to give a speech to us. We weren't just going to listen. You can tell we find it difficult to keep our mouths shut. And you were able and willing to be flexible, to understand, to answer our questions, to not say, I'll get to it, which is the thing that bothers judges the most. So that's one thing. The second thing was the willingness to acknowledge weakness in argument and to make concessions. Make concessions to narrow your case down to what you really needed to win and to give up on lines of attack that were impossible in the end to win with. And I think both of those are, all four of you reflected both of those points, and I think those are the hallmarks of a mature appellate lawyer. And I was quite impressed. Don't tell any of those lawyers back in D.C.
The court will adjourn to the recess, to the reception.